Minister in the Office of the Attorney General.
Mr. President, I thank you most sincerely for the opportunity to join this debate. You know, Mr. President, coming in very early in this debate, thankfully, the only opposition member that I have to really respond to at this stage is Senator Mark, which I will do in a bit. I want to, recognize, of course, the contribution made by Senator C. Prasad. And of course, during the course of my presentation, I'm hoping, Mr. President, that I'll be able to address some of those concerns raised by the Honourable Senator. But as I begin my presentation, and of course, the structure of my presentation, Mr. President, I would, of course, deal with some of the, again, misinformation and the propaganda placed by Senator Mark, the fear-mongering placed by Senator Mark on the record. I will deal with that, and then, of course, I'll get into the substantive crux of my presentation, which, of course, I'm hoping will deal with certain issues or concerns that the Honourable Senator C. Prasad has. But, I just want to begin by, because that's the place that Senator Mark began. In his contribution, he spoke about, this being an extraordinary sitting where we were all summoned here. And I'm dealing with that issue very briefly of extraordinary sitting for the benefit of the members of the listening public. Mr. President, most respectfully, and for the public who is listening on, had Parliament not been prorogued, had the Parliament not been closed, this would have been an ordinary sitting in which we would have come to this Honourable Senate asking for this bill for the Procurement Act to be amended based on circumstances. And I'm saying that because I've seen a lot of people reach out to me on social media concerning the extraordinary sitting. Of course, it's because of the fear-mongering that the opposition is putting out there, as if this is a Section 34 sitting that is happening. And I want the public to rest assured, Mr. President, that the extraordinariness of this sitting, in a sense, is because the Parliament is prorogued. There is now something on the books that it requires us to address. And as a consequence, Mr. President, we have had no other choice as a government to recall the Parliament for us to be able to listen, for us to be able to treat with this legal issue that is before us. And that is one of the first places I wanted to start because, Mr. President, as I indicated, I know people would have reached out to me on social media, of course, because again of the fear of what is this extraordinary sitting about, and I just wanted that to be stated. Now, as I jump into some of the other points made by Senator Mark, I am really now thinking the UNC has to change its name from UNC to Control C, because Control C in a Mac computer is where you press copy and paste, is where you Control C, you copy and paste an argument. And why I say they should rename themselves as Control C, Mr. President, is because honestly, the poor opposition leader, Mr. President, Senator Mark, again, Control C her entire presentation and came to the Senate again. And I can say verbatim because I listened up until last night, 11 o'clock last night, to the House presentation. And the opposition leader, I listened to her presentation. The Minister of Finance went all around the world to justify the negative resolution. But right here in our region, Jamaica's procurement legislation still states that it's subject to an affirmative resolution. And the opposition leader said that in the other place. And Senator Mark, in true to form UNC Control C style, came here and regurgitated verbatim what the opposition leader said. So again, it makes it very easy for us on the government bench to be able to respond to them, because in advance we know what they're going to come to say, because it's just really a Control C syndrome that has been operating here. But Mr. President, other than that, which I mean they're free to do, there were other points made by Senator Mark, which is certainly concerning to me, since I am very new to the Senate and Senator Mark is a seasoned politician. As a matter of fact, I always say to Senator Mark, especially because I sit with him in a PAEC, And the fact that in my tenure, my short tenure in being in this parliament, he is really the only member of the opposition bench that ever champions any cause. And I always say to the Honourable Senator, you know, as a new young politician, that is something I recognize. And I would expect, because of his experience as a politician, he would not have come here today, Mr. President, and said what he said, which was, I call upon the government to present forthwith a detailed expenditure of what was spent for those CARICOM meetings. And he even requested or demanded that the Minister of Finance leave and comes back with that expenditure today, so that the entire Senate can now review this. Mind you, review this in a matter of an hour or so, well, however long this sitting is. I would have expected, Mr. President, and that's why I started by speaking about his experience. I would have expected that a man of his experience, because he always speaks about being in here from the time when he had here, all right? And you know, and he said that in the Senate. I would have expected that Senator Mark would understand, as other members of this Honourable Senate understands, that that is where, come to the end of fiscal, Mr. President, when we go through the deliberation of a standing finance committee, that is where all of the expenditure, Mr. President, that has been utilized, taxpayers, I'm a taxpayer, and of course I'm concerned about how taxpayers' dollars are utilized. This parliament, that information will be brought to this parliament, and we will not be able to, we won't have to rush the going through that expenditure line item by line item, head or by head, expenditure by expenditure. The entire parliament will have an opportunity, the entire Senate and the House of Representatives, will have an opportunity, line item by line item, to scrutinize, Mr. President, the expenditure coming out of that summit, and even the judiciary order, the order that was given to the exemption order that was given to the judiciary. The judiciary does not, the judiciary appear, I know it appears under the Office of the Attorney General and Ministry of Legal Affairs, and their finances will be presented at a standing finance committee stage and will be subject to scrutiny by all members of the House of Representatives. And that's why, Mr. President, I started about speaking about the experience of Senator Mark, because to ask for it to be presented here today, it is rubbish, respectfully, Mr. President, because there is a parliamentary process in which that information will be forthcoming, and the citizens of this country and all honourable senators can rest assured that there will be an opportunity for that accounts to be scrutinized, Mr. President. You know, and that, you know, to answer to Honourable Senator Sipasad's concern, that is us discharging, the government discharging their fiduciary duty and responsibility to the country. Once we go and hit the floor with those standing finance committee meetings, that is where the line ministers will now be responsible for answering to every single question, every single query, line by line concerns that the public or the government, the opposition may have relative to that expenditure. And I just wanted to make that very, very simple point, Mr. President. You know, Mr. President, Senator Mark went on to make reference to a press release. I have not seen the press release, and honestly, I have not been able to verbatim document everything that he said. But one snippet from that press release was that that the Honourable Senator indicated was that these entities were saying they're not supporting the legislation because you can't mix administrative issues with legal issues. And again, Mr. President, most respectfully to all of the entities, and of course, bearing in mind that I have not read Wholesome, because we know Senator Mark has a habit of cutting and pasting, one, and two, he might deliberately leave out certain things from the press release. So unfortunately, I can't believe, I can't trust everything that was placed on the record without the benefit of reading the report, the press release. But Mr. President, how is it really possible for us to separate administrative issues with the law when the law is responsible for preventing ministries and entities from conducting their discharging their administrative responsibilities and duties? So I want to just say that, I mean, to my mind, and that's why I mentioned I have not read that release in a Wholesome, fully, but I cannot see, especially where there are issues existing on the legislation that is preventing preventing effective administration in ministries and NGOs and all those that are considered as public bodies pursuant to the procurement legislation, I cannot see how we could separate those two issues, Mr. President. You know, Mr. President, also, Senator Mark spoke about the hallmark of the procurement legislation as being integrity, that predicated on integrity, transparency, honesty. In the crux of my presentation, Mr. President, especially when I deal with the issue of negative versus the affirmative resolution and other areas of the law and other checks and balances that are still existing in other pieces of law, I'm hoping to deal with that concern that Mr. Senator Mark would have placed on the record, whereby he is suggesting to the public that the amendment that we have brought today is somehow or the other an attack on the cornerstone or the fundamental principles of this procurement legislation, which is really that of integrity, transparency, and honesty, and I will get to that point. Also, as true to form, Senator Mark, I don't know what is his obsession with the poor Minister of Finance. Again, he asked the question, what is the Minister of Finance doing there? Why is he placing himself in this amendment? Mr. President, to answer to the Senator, when I get into the crux of my presentation, I will look to the Constitution and again remind the Honourable Senator about what is the constitutional role and function of the Minister of Finance. So when the Minister of Finance places himself in certain pieces of legislation, he is empowered to do so via the Constitution of Trinidad and Tobago on other pieces of legislation. And I will get to that, Mr. President, when I get into the crux of my presentation. But before I conclude some of the points that Senator Mark made, I have to make mention, Senator Mark and the opposition has a habit of coming into the Senate and dirtying people's name and calling up people's name. And I have heard him today speak about Miss Beverly Khan, the new OPR, calling up again people's name and suggesting, of course, that, there's some sort of political affiliation because she sat on the board of directors of WASA. Why is it that Senator Mark can't remind this public that this Miss Beverly Khan is a woman of more than 30 years experience in the public service and therefore is fully equipped and in a position to conduct her roles and her responsibilities? But he will not do that because it will not serve the opposition's intention and their purpose. So rather he will come here, cast aspersions about, slander people's name, call up people's name in his mouth and not speak to what the validity and of course the value, Mr. President, that some of these persons can bring to the office that they serve. Not forgetting to, Mr. President, just to place on the record, the previous regulator, Mr. President, Mr. Munilal Lalchan, he was the chairman, Mr. President, of Creative TT. He was the chairman of Creative TT. And not under our administration, Mr. President, under the PNM. So that is important for us to understand, Mr. President. So what that suggests, Mr. President, and there were many, I recall hearing and reading in certain aspersions made about that previous office holder, but that individual sat under a PNM government on a state board, Mr. President. Does that make the individual incapable? Whatever his political affiliation is, does that make him incapable of performing his functions, roles, and responsibilities? I do not believe that. And the modus operandi of this government has always been, Mr. President, has always been, if you have the skill set and you have the ability to be able to perform a certain function, our government, led by our political leader, have no qualms about putting the right people in the right places to serve. And that has always been the modus operandi of our government, recognizing talent, harnessing that talent, and as I said before, putting the right people in the right places, not people with 2 CXC, putting them to head the big organization. And no, we don't do that, Mr. President. So, Mr. President, I just had, as a regular citizen of this country, I am sick and I'm tired and I'm fed up of the UNC coming here and slandering people's name and calling up people's name because you know why? They know they have the protection of Parliament here. And I just felt that I had to make a point about, Ms. Beverly Khan. Mr. President, as I move now into the crux of my presentation, Of course, the Minister of Finance, of course, I once again commend him for recognizing that if there is a need for us to bring forth changes in the law, that is why we are here today, in order to bring forward those changes. The first thing that I want to deal with, Mr. President, I know the Minister of Finance would have dealt with it in his presentation. Mr. President, I want to look at, of course, Clause 4 of the bill, and specifically looking at that in Clause 4, Mr. President, of the bill that appears before us, which seeks to amend the Act by inserting, of course, Section 58A, which states, Mr. President, subject to regulations made under 63, the procurement of goods and services up to $1 million are exempt from the procurement requirements under this Act. Now, I know the Minister of Finance would have, of course, in dealing with that particular section, that particular clause, Mr. President, he would have identified subject to regulations that is included in the clause, the amendments that are brought, and he would have gone to length in explaining what that subject to regulation means. And the subject to regulations, of course, he would have reiterated in his presentation. It shows that that is one of the first checks and balances that is going to be put into place in dealing with that, with especially PSs and those public officers who can now, that $1 million cap that is now exempt from the public procurement, from the legislation. So I know he would have dealt with that. But what I want to look at, Mr. President, I want to lawyer up the thing a little bit. I want to look at other checks and balances, Mr. President, and remind this Honourable Senate and, of course, members of the public who may be concerned about that $1 million cap of other checks and balances, both in the law and otherwise, that exist, that will ensure that if there is indeed some sort of misbehavior in a public office, even as it relates to that $1 million that is now exempt from procurement, the regulations and so forth. Well, not the regulations, because it's subject to regulations, but of course that $1 million cap that persons may be concerned about. I want to deal with the law, Mr. President, as it relates, the existing law, Mr. President, as it relates to providing checks and balances. Now, Mr. President, I want to read into the record a case. Well, first to begin with, Mr. President, the Minister of Finance would have gone through the history of where that $1 million cap would have emerged from. And of course, in his deliberations, he would have mentioned a significant amount of international comparators. I know the Minister would have looked at Australia. He would have looked at the UK. Mr. President, I recall in my research as well, in trying to determine or looking at that $1 million cap, I would have, of course, looked at other regional comparators in which, in their procurement legislation, Mr. President, there are similar caps that are in existence. So, for example, if we look at Barbados, Mr. President, if we take the Public Procurement Act of Barbados 2021, that has in its genesis, of course, the Protocol on Public Procurement for the Caribbean Community, signed and ratified also by St. Kitts and Nevis in 2019. And Part 2, Mr. President, of that particular comparator, Mr. President, entitled Scope and Coverage, specific in Appendix A, tells us that goods and services not exceeding 150,000 US are exempted from the Protocol on Public Procurement, and that is in the Bajan legislation. And if we translate that into TT dollars, let's say we're looking at a 6.7 exchange rate, it comes up to about $1 million or so plus dollars. That is almost the same. That is the same cap that our legislation speaks to. So I just wanted to add it to, some of the comparators that the Honourable Minister would have spoken to by, putting on the record that in Barbados, there is also said cap that is in existence. Mr. President, also, when I looked at Antigua and Barbuda, if we look at the Procurement Administration Act of Antigua and Barbuda, 2011, what we have in that legislation, again, regional comparators as it relates to this cap that we have brought the amendment that exists, Mr. President, in Clause 4. If we look to that piece of legislation, Mr. President, we see, and this is what the Antigua and Barbuda Act states, similar clauses exist where Schedule 1 notes that procurement for hospitality and catering services with a value equivalent but not exceeding, and they went on to speak about almost 25,000 Eastern Caribbean dollars, which is approximately 63,000 TT dollars, is exempt from procurement legislation. And their legislation, Mr. President, it goes through in detail, Mr. President, other instances similar to our amendment that we have brought here today, Mr. President, in which you can have a similar cap in existence. So I just wanted to place that on the record. I also want to add a little to, I know the Minister of Finance would have looked at the European Union. Mr. President, of course, within the European Union, specific utilities, markets in certain countries may be exempt from public procurement rules. And I can list, Mr. President, coming out of the EU Procurement Directive for utilities. Some of those things will include utilities, water, energy, transport, postal services, are essential for the smooth functioning of our economy and social development. That's actually verbatim out from that EU Procurement Directive. These are some of the services that, of course, benefit from falling in that exempt list, because they recognize that, of course, there are certain industries that really and truly you can grind your public service to a halt, or you can grind service to your citizens to a halt if you have to go through the rigor of and detailed procurement legislation has to apply there. It can really provide that blockade to being able to fulfill the needs of your citizens and so on. So I just wanted to add that as it relates to comparators, and of course to add to why this $1 million cap, this $1 million threshold, Mr. President. Now, the unfortunate thing, and I've heard the Prime Minister speak about this, the unfortunate reality in our society is the issue of the mistrust of the public, and the public not trusting officers and office holders. And we know a large part of that started from the UNC's tenure, Mr. President. But unfortunately, Mr. President, to the man on the street and the regular citizen, I know one of the major concerns that any government will face, whichever government sits where we sit today, would be because of that level of mistrust that the public has for office holders. And it's unfortunate that some of those before us would have created that image of what public holders are. So unfortunately, new and, politicians like myself, that is the unfortunate reality and mold we are placed into. But what I want to do, Mr. President, is to the benefit of the listening public, especially those who may be concerned about the abuse of that cap, is to remind the public, Mr. President, that of course the checks and balances that will be provided would have been one of the checks and balances that the minister spoke about, subject to regulations, and those regulations which will come relative to how that cap can be utilized, and that threshold, with reference to that threshold. But beyond that, Mr. President, I want to revert the public, I want to take the public to the common law, Mr. President, on the law as it relates to misbehavior in public office. And Mr. President, the law as it relates to misbehavior in public, and we have a lot of cases even coming out of our jurisdiction, Mr. President, that, and many of the cases, of course, certain members of the UNC bench. But Mr. President, what I want to read into the record, Mr. President, is that if, for example, and there's just two cases that I want to speak about when I look at the checks and balances provided in the common law as it relates to the misbehavior in public office. And the first case that I want to look at is Belize International Services Limited versus the Attorney General of Belize. And in this particular case, Mr. President, at paragraph 340 of the judgment, it was stated, notice how accountability, equality, and respect for persons, contracts, and property, as well as administrative fairness, features as essential aspects of the rule of law. The rule of law, accountability, and transparency, open brackets, open government, close brackets, intersect to produce a government that is legitimate. In democracy, accountability and transparency are essential for public trust and confidence. In a democracy based on the rule of law, it is now the expectation that all aspects of government ought to be appropriately accountable. Now, the value and principle of accountability can broadly be said to refer to the idea that generally state decisions and makers are accountable for their decision. And when we talk about state decision makers, and we are not only referring to Mr. President, to politicians, Mr. President, we are referring to even those who hold the office of permanent secretaries and accounting officers in ministries, Mr. President. And I had to remind the public that if there is indeed a concern that there is going to be an abuse of that threshold, please be reminded that, and the UNC always speaks about going to court, and we know they are a very litigious group, but the public can rest assured that there are other safeguards and checks and balances, Mr. President, for any officer, be it politicians, myself included, Mr. President, or public officers, Mr. President, which will include those permanent secretaries and so on. If there is evidence that even that threshold, Mr. President, is in one way or the other abused. So the legislation itself, Mr. President, while yes, there are sanctions in the legislation, criminal sanctions as well in the legislation, for of course, if there are certain breaches by these officers, let us also be reminded, Mr. President, that there are other checks and balances provided in the common law as it relates to misbehavior in public office that will not only apply to politicians, Mr. President, but it will apply to these office holders, of which would include, the public servants, the permanent secretaries and all of that. Mr. President, also, what I want to look at is the case, a local case, Mr. President, is Trin Salvage Enterprises Limited versus the Attorney General of Trinidad and Tobago. It's for the benefit of the Hansard, Mr. President, if you allow me to read it, CV number 2011-04593. And I want to take a little dicta out of this piece of legislation because it was actually a case which dealt with, and I know it was a concern that was raised in the other place, and I don't know if it may be a concern of other members here. In a nutshell, it had to do with, okay, the $1 million cap, but you break up a $10 million contract into 10 different, you break it up into $10 million contracts, and you split up the splitting of contracts, of course. And I just try to break it down so at least to the benefit of the public who's listening will understand what is the issue this case specifically dealt with. So that in a nutshell, Mr. President, was the facts that came before the court. And in this particular case, Mr. President, so if I may read, which concerned the cause of action in this case, Mr. President, was for a cause of action for breach of contract. And the court considered the issue of whether the permanent secretary in the Ministry of Works and or Lee Young and partners had the authority and or apparent authority to enter into alleged contract on behalf of the defendant, and whether any lack of such respective authority would deprive the claimant of its claim on a contract or under its claim for quantum merit, right? Now, in this particular judgment, Mr. President, the decision of another local case was cited, and I want to place that case on the record. That case was the Attorney General versus Motilal Ramhit and Sons Limited for the benefit of the Hansard Civil Appeal number 124 of 1996. And this is what the Transalvage case, as I said, said before, it cross-referenced in its judgment, a 1996 judgment. And this 1996 judgment, which concerned the legality of contracts award by a URP supervisor, where it was contended that he did not have the authority to award contracts as it was done without approval from the Central Tenders Board by virtue of dividing smaller contracts into small divisible contracts under $5,000. So that case also dealt with, Mr. President, with the splitting of contracts. Now, in this case, Mr. President, the court stated that the work was to be done in sections from week to week, and weekly invoices had to be submitted, because those were the facts coming out of the case, had to be done in sections from week to week, and weekly invoices had to be submitted for sums not in excess of $5,000. Now, at paragraph 18, Mr. President, of that judgment, and this is what I believe is important, was quoted where the court cited that Chitty on Contracts, the 25th edition, paragraph 115, which stated that where a government agent breaches the ordinance in the absence of knowledge or collusion, right? Breaches the ordinance in the absence of knowledge or collusion, the other contracting party is entitled to avail itself of its civil remedies. The respondent is therefore entitled to recover the sums claimed. Accordingly, Mr. President, where a public officer acts outside of the remit of his scope of duties by awarding contracts and even dividing contracts into smaller lots for the purposes of evading the law, he is liable for such an action. And this case went on to find the parties, the liable parties, of course, liable based on the case that was before it. And of course, I don't want to bore the Senate and the members of the public by lawyering up the thing too much. But I had to remind the members of the public, because I know, that's why I started by speaking about the public's perception of, unfortunately, what politicians are, and not trusting politicians and not trusting office holders. I want to remind the members of the public that there are other checks and balances and remedies in the common law as it relates to misbehavior in public office for any office holder, Mr. President, from a PS to a minister to any office holder, Mr. President, that may be found in flagrant breach of the legislation that appears before us. Mr. President, also the other checks and balances that will exist, Mr. President, we need to understand in all of these entities that form states that the legislation refers to, especially state entities, Mr. President. There's what we call the internal audit system and auditing system of these organizations and entities, which is yet another check and balance on what is done and how contracts and people. I remember when I sat on the board of directors, for example, of Export TT. That was in a previous incarnation, Mr. President, the subcommittee of Export TT that was created. I was in charge of procurement and tenders. And I recall those subcommittees, when we met, we would go through with a fine-tooth comb, or a fine-teeth comb, however you say it. We would go through in detail, Mr. President. We would go through with a fine-teeth comb, Mr. President, detail by detail, the expenditure and what came before us. So what we must remember, Mr. President, for the members of the public or even members of this House who may have concern about that $1 million threshold, the minister have indicated, and the legislation that is before us indicate that is going to be subject to regulation. That's a check and balance. Another check and balance is available in the common law, as I would have referred this Honourable Senate to cases on misbehavior in public office. Who will be subject to misbehavior in public office? And then, of course, there's an abundance of cases that already deals with that bid split, that contract splitting of contracts and all of that. That's another check and balance. A third check and balance that is available, Mr. President, is those committees that are created into these entities. I would have made mention of my personal experience. There's also the audit committee that is created in these state entities. And these audit committees, if they function, and I heard Senator Sipasad call on public servants to do what they have to do, and I endorse that position. Persons who sit in these committees, who sit as board, who sit on boards, who sit as directors, they have an equal responsibility and an equal role, Mr. President. It's not just the members who sit in the Senate as members of the government or any other place as members of the government that has a responsibility. If we want to eradicate crime and criminality in this country, every single citizen, Mr. President, has an equal part to play. And that those committees, Mr. President, that exist in these institutions, the audit, the finance committee, they are examples of committees, other checks and balances that are in place in state entities, and all those who will be considered as public bodies, Mr. President, to ensure that, that you keep an eye on expenditure in the organizations. Then, Mr. President, we must not forget that all these state entities are then subject to the scrutiny of Parliament when their annual reports are submitted to the Parliament. Senator Mark sits on a PAEC, which I mentioned before, in which I sit as a member, Senator Laura Lazama Leasing. So there's the PAC and all those different committees, Mr. President, in which audited finances, in which financial reports of these entities come before the Parliament. That is subject to public scrutiny. Those joint select committees, Mr. President, it's not a government bench alone sitting there and analyzing these reports. It's members of the Senate, it's members of the independent bench that sit there and have an opportunity, Mr. President, to interrogate expenditure. I remember when EMBD, we had a PAEC, I think, on EMBD. I scrutinized in detail some expenditure for a photographer. And it was small money, but I felt I had the need to ask the questions, and I asked the questions. And I have sat in JSCs where members of the opposition bench, members of the independent bench will scrutinize to the last cent, which we are entitled to do, which is why we sit in this place in the first place, for transparency, for accountability. So I want to remind the members of the listening and viewing public, Mr. President, of course, I remind respectfully the members of this Senate that there are multiple checks and balances that will, especially as we relate to that, we talk about that $1 million threshold.
Minister, you have 5 more minutes.
Yes, Mr. President, thank you. Within these committees. Then, of course, Mr. President, we must not forget the role of the Auditor General. And, of course, legislation speaks to his role and his responsibility. And, of course, time is against me, so I will move from this point. But as it relates to that threshold, as it relates to that accountability, as it relates to that transparency, Mr. President, I support the Honourable Minister in the legislation that has been brought here, because to my mind, not just as a member of the government, but as a citizen of Trinidad and Tobago, I believe there are several areas in which there are checks and balances that will and can be placed, Mr. President, or that, on checks and balances in place to scrutinize that $1 million threshold. Mr. President, you said I had 5 minutes, correct? Yes. Thank you, Mr. President. So that is one of the issues that I want to deal with. I did mention that, Senator Mark asked the question about the Minister of Finance and his role and responsibilities. What is he doing, placing himself there? Mr. President, because of course he made reference to Clause 5, proposed Section 63, but we would have also seen, Mr. President, well, especially in Clause 3 last night in the House of Representatives, there were amendments, Mr. President, that was made to the, and therefore it's a new bill that appears, an amended bill, that appears before the Senate today. But I just want to remind the Honourable, Senator, Senator Mark, and this is to reiterate, because I don't know what is his personal issue with the Honourable Minister of Finance, but the Minister of Finance has never come to this Parliament, Mr. President, and stepped out of the remit of what his constitutional and his legal role and responsibilities are. And this bill is no different, Mr. President. And, Mr. President, if we look, for example, to the constitutional role of the Minister of Finance, just to briefly state, the minister responsible for finance caused to be prepared and laid before the House of Representatives before not later than 30 days after the commencement of each financial year, estimates of revenues and expenditure of Trinidad and Tobago for that year. That's 1. 2, the heads of expenditure contained in estimates other than expenditure charged upon the consolidated fund by this constitution or any act shall be included in a bill to be known as an appropriation bill, providing for issues from the consolidated funds and sums and so on. Mr. President, this insertion, I just want to state for the record, the Minister of Finance, there is the whole length and breadth of the Constitution. There are other pieces of legislation that speaks to his role and responsibility. And please, for the benefit of the listening public, this is not the Minister of Finance overstepping his boundaries or overstepping his responsibilities, and I certainly will not belabor the point because I know time, of course, is against me. As it relates to negative, I know there would be some concerns about the negative versus affirmative resolution. The Minister of Finance, of course, would have dealt with the issue of emergency circumstances, situations, and the reason for, looking at this negative versus why we have come to the Senate today proposing a negative, for these changes to be brought via negative as opposed to affirmative resolution. And I want to recognize, Mr. President, that on the 8th of December 2020, yes, the Senate, in this very said place, Mr. President, there was an agreement based on suggestions and based on recommendations made by honourable members of the independent bench, where the government would have rejected, we would have abandoned the issue of affirmative resolution and of course negative resolution, and we would have accepted the recommendations made by the honourable senators, the independent senators. And I've often heard the question, so what has changed since then? And just to reiterate, Mr. President, what has changed since then is the operationalization of the bill. And in the operationalization of the bill, Mr. President, there are serious challenges that ministries are currently facing. And Mr. President, I have sat in some of those open consultation, after the bill was proclaimed or leading up to proclamation, also after proclamation, and I could see and sense the fear of numerous public servants as they took the microphone in those sessions, reiterating the concerns and challenges they were having, and of course, in their own unique ministries. And of course, to give examples in detail, it would take us probably from now, according to Indian people, until the next Janam to be able to go through that point. But, Mr. President, that is what has changed. It is not that the government is watering down the legislation, but since operationalization, Mr. President, we have recognized through real challenges, which of course we now require, especially in some of those emergency circumstances that we need to deal with. I asked the honourable senators to also look at Regulation 12(1)(f). It's not just emergency circumstances, Mr. President. There's urgent public interest issues that you may also be required to make a decision, and the legislation, the parent legislation, will prevent you from doing that. And then there is also the Act speaks to unforeseen circumstances. So we have emergency. I wish I had more time to go through that, but I'm sure other members on my bench will do that. So, Mr. President, with those few words, which I'm sure my other members on the bench will go through, I thank you for the opportunity.
Senator Vera.
Thank you, Mr. President.